versus Barrage Scott.
Caitlin Kirby on behalf of the people.
All three.
Conda White on behalf of Barrage Scott and 22 FP 1390.
And Michael Gaddy, Assistant Public Defender, on behalf of Mr. Scott on 23 F2 413 and 23 F2 217, Judge.
Got it. Okay, what are we doing?
Your Honor, I haven't had a chance to discuss this matter with Mr. Scott. There is an offer pending on the unarmed robbery, the 413 matter, that if you were to waive, the people would add a count of larceny from a person and dismiss the unarmed charge. I have had a chance to speak with Mr. Scott, and I reached out to Ms. Kirby about any video. Happy the video came. There's about 15 videos that came yesterday evening. I haven't had a chance to look at them. I'd ask the court to adjourn these matters briefly, keep the offer open so I can.
This our matter is also included in that offer as a global resolution, so I guess we would adjourn also, and I would like to address bond when ready.
Go ahead, you can address bond. I'll set probable cause in these matters will be adjourned June 1st, 2023, 9 a.m. Go ahead, as to bond.
Your Honor, we were last year, there was a bond violation that occurred on April 17th. Mr. Scott tells me that he had went to the hospital and then he had walked home. So that may have been part of it. And he may have been accidentally outside his zone, but he was just on his, how do I say it, on the sidewalk down the street. So he's unsure if that was part of it also, but he did go to the hospital that day. He is trying to get into outpatient treatment voluntarily. He also has a tutor now available for school. He found out when talking to his grandmother the other day, and he wants you to know that the jail is overcrowded. So he is hoping that you will let him out on a PR or PR with a tether. And if you are concerned about his being out, you could tether him to home confinement.
I did that the last time. And we keep ending up in the same situation. So what I say is let's get these done and then we can see where we can head from there. Motion for bond reduction is denied. Bond will continue. Thank you.
Can I say something, Mr. Simpson, please? Just one time.
Really,
Please.
not going to help you, but go ahead.
I know it's not gonna help me. Listen, they said, and they was gonna bring up that I was doing so good on house confinement the last time, and I have did good. I learned my lesson, Your Honor. I learned my lesson. You told me not to go back into the store panhandling or doing none of that stuff, and I haven't done none of that stuff. I did go to the hospital, and I still have my wristband. I still have my wristband, and you said if it was on the 17th that if I didn't lie, and you said you might put me back on the tether. I'm really hoping that I can get back on the tether. I'm sick of being here. I'm tired. I learned my lesson. I won't do it no more. I will not do it no more. I'd rather be on house confinement. I told you I would rather get in drug outpatient treatment. I haven't never did that. You know, I'm trying to get my life back to right. I just want one more chance. I don't want you to keep me in jail, and
Mr. Scott, let me just stop you. There have been time and time again that you've appeared before me. I've released you. I've tried to think of creative ways to release you. I put you out there under different circumstances. And regrettably, Mr. Scott, we always end up back here.
But
you were doing well for a while, and then we're back here again.
But I'm saying,
not doing it anymore.
Listen, can you listen to me, please? Can you at least?
I've listened to you.
This one chance I asked for, and I promise you, you won't regret it, Simpson. Please, I got a lot of stuff.
Mr. Scott, I've given you at least 10 different chances.
I'm saying, can this be the last chance you give me and I won't mess up?
That was what the last two were.
I know, but the last two you let me go. You said it wasn't my fault because the power was out, so that really didn't count as my last two. This is my time. I'm asking for it now. So please, can I get one more chance to go home and be on house confinement? I will not leave the house. I promise I will not leave the house. Please, I'm finna cry, bro. Like every time I ask for a chance, people give me a chance, but it's not willing to mind effect. I just want one more chance. If you give me this one chance, I promise I won't violate. I won't go out the house if you put me on house confinement. I want to be around my family. Just give me this one chance. If you give me this one last chance and I mess up, then it's meant for me to be locked up. But I just want one chance, just one more chance I ask for in life. And if I mess up, then it's meant for me to be locked up. But I don't want you to not.
That's what you told me the last couple times.
I know, but this is the last.
I made my ruling, Mr. Scott.
I know, but listen,
Mr. Scott.
Mr. Simpson, please, can you just one time?
I made my ruling.
One time. I don't want to keep being in here.
Mr. Scott.
You don't understand me. My little sister died.
Yo, don't tell me that.
I'm saying.
Don't even try that, Mr. Scott.
But I'm being honest. What am I supposed to do if you don't want to give me one more chance in life? You think I want to keep staying being in here? I have.
Mr. Scott, time and time again, I've let you out.
All right, but
you want me to list them all? And some of them don't even apply to this case. And then what ends up happening? You end up back here. You keep saying you want one more time. I'm done right now.
All right, Mr.
That's
Simpson.
it. I've made my ruling.
Simpson,
That's it.
Listen, all right,
Mr. Scott.
How about this, Mr. Simpson?
Mr. Scott.
Can I
I'm done.
Can I explain myself?
I have made my ruling.
It's being like
Mr. Scott.
I can't even.
That's it. I'm done. Cut him.
Please subscribe to help the channel.
Address the issue of bond.
You may.
Thank you. Your Honor, my client is respectfully requesting that this bond be set at personal recognizance. He does have a home at which he could stay that would be away from the complaining witness in this matter. And he's asking that he be allowed to return to all future court dates. He will follow all restrictions and strictures of the court.
Response?
Your Honor, due to the nature of the charges, I would ask that the bond not be reduced. Also, I have very serious concerns for victim safety. We have been in contact with her. She has a large fear of the victim. In this situation, he had a handgun, which he then assaulted Miss Johnston with. We have talked to her. She has since found some cameras in her home that she also did not place, and she believes that the defendant may have placed them. I don't have any further evidence on that, but that is part of my concern. He also is a felon. He is not supposed to possess a weapon and or ammunition. He had both in this case. So I would ask for the bond to remain the same, given that the preliminary examination is set for the 20th.
In a very brief response, Your Honor, my client indicates that at this time, the complaining witness has attempted to do certain financial transaction device frauds. She is basically taking all of his property and his money while he's incarcerated. He vehemently denies the allegations in this, and he expects to be exonerated, if not at preliminary examination, at trial itself.
He denied. I understand his denial of the allegations, but he also denies having to have been tased once the police arrived, and he would not let them in as the victim was yelling for help.
As we stand right now, he is innocent of all charges. Those are
okay. Well, the tasing isn't a charge. I'm just trying to figure out what happened on that day. And I understand the reluctance in that, but that's what the court has. So given that, motion for bond reduction denied. This bond will continue as set. Thank you.
Thank you.
Mr. Davis, can you state your name for the record?
Mayor Dwayne Davis.
Thank you, sir.
In this matter, we would like to set it for a prelim, and I would like to address bond when able.
Of course you would. Preliminary examination in person, June 20th, 2023, 9 a.m. That will be before Judge Freshour. As to bond.
Your Honor, Mr. Davis has been in for about 9 days. He does have a residence in Ypsilanti Township. And I'm sorry, I don't have my notes in front of me. He does understand the no contact with the victim, and we have talked about that extensively. So we're asking for a PR bond.
Response.
Your Honor, the defendant failed to appear on 5/25. And given the nature of the facts here, the victim is pregnant and she had severely bruised eye and also bruises to her face and arms. And he's also had 2 previous DV convictions as well. So we would ask that the bond remain as it is.
If I may respond.
Okay.
The PCC that he missed, he thought that he did not have to be present for. Apparently he's been to another county with the PCC and he was told he did not have to be present. So
Really?
That's what he thought. So,
Really? So welcome to Washington. Go ahead.
Can I say something?
just a second, Mr. Davis. And as to the previous DVs, I do believe they were dismissed. And he is willing to wear a tether.
I don't think they were dismissed. I think he has 2 previous convictions. I think that's what was indicated.
Okay, he thought they were dismissed.
Okay, anything else?
No, Your Honor.
Can I say something, Your Honor?
Not about
Go
the
for
case,
it.
Mr. Davis.
All right.
Your name, please.
Yes, Nathan Wade.
Preliminary examination will be in person June 20th, 2023, 9 a.m. before Judge Freshour. As to bond.
Your Honor, as it relates to Mr. Wade, he has 0 criminal record. I'll repeat, 0 criminal record. The allegations in this matter do not deal with any type of weapon. There is clearly some issues about a domestic matter as it related to the charging. He had complete access. Well, I'll move past that. He has a family support. His mother, his stepmother, his father, Erskine Wade, the boxer, runs Kronk Gym. The entire family is aware of the situation. He would promise to have no contact with the complaining witness. If the court would be inclined, he would ask to be released on a tether or a nominal bond in this matter.
Response.
Yes, Your Honor. Numerous things. As to the argument about that he had access to the home, it was actually at arraignment that the defendant himself said, the prosecutor said I broke in because I have the code, but actually I have keys. He actually had no permission to be in there at that time. The allegations in this case are very serious. They were formally dating. He was attempting to disable her home security, and every time he attempted to disable it, she would try to re-enable it. She was in fear for her life. He threatened to kill her. This is a situation where he laid in her bedroom until she got home, lying in wait for her. He then attacked her. He hit her repeatedly until she was in and out of consciousness. He then strangled her, upon with the threats to kill her. She did call 911. She was successful. The defendant then took the phone from her, threw it against the wall. She tried to escape and numerous times, but he kept pulling her, preventing her from leaving. She tried to get down the stairs. She tried to make it through the floor, but he continued to pulled her back by her hair, punched her in the face numerous times. He prevented her from leaving. He continued to beat her until until he tired himself out and then left on his own. She drove herself to the emergency room. There's tons of unprovoked violence in her own home that he had no permission to be in. So I don't believe a bond reduction is necessary or should be done. Thank you.
Anything else, Counsel?
If those are the facts alleged by the prosecutor, I'll look forward to the matter at the preliminary exam. I'm not going to get back and go back and forth until then, as it relates to his access to the house, because they were business partners and he'd constantly been in the house. But with that said, 0 criminal record, no risk of flight whatsoever, no weapons involved, no criminal record.
Motion for bond reduction is denied in this matter. Bond will continue. See him on the 20th before Judge Freshour. Thank you.
Very good. Thank you, Your Honor.
Please subscribe to help the channel.